My name is Justin Levitt. I'm an Associate Dean for Research at Loyola Law School in Los Angeles. I had the privilege of serving with the Department of Justice for a brief period at the end of the last administration. I have been working on redistricting now for some decades and following the path across the country. I say this is an immensely difficult time frame because we're set up competing with another incredibly important session on how race works into the redistricting problem. And I just wanted to start off by saying you could very well be at either panel, because you'll find that in this area across the country, and particularly in North Carolina, you cannot think about redistricting on a partisan basis without also thinking about race, and you cannot think about redistricting on a racial equity basis without thinking about partisanship. They are inherently intertwined, and some of the very same problems that we encounter in this zone are problems that racial minorities are encountering all day, every day. And so it's a nice thing to be talking about redistricting while there's also a conversation about redistricting and race going on, but don't think for a second that we don't know that all of our conversation is also in some ways a conversation about race as well. And both of the gentlemen I have the privilege of sitting here with, of being on this panel with, have been litigating in the fields, in the redistricting area, also on the basis of civil rights and racial representation for a very long time. First, to my immediate right and your also immediate right, which works out nicely, Emmett Bondurant, a nationally recognized trial lawyer, been doing this for more than 50 years, worked on the case that really opened up the reapportionment revolution in the 60s, requiring that congressional districts be equally populated. And as far as I can tell, hasn't slowed down since. He is a fellow of the American College of Trial Lawyers and the American Academy of Appellate Lawyers. He has been doing an enormous amount of pro bono work and public interest work in his practice for decades. And he is one of the lead counsels in the North Carolina case going up to the Supreme Court. And we're going to hear a whole lot more about that, as you've heard a couple times today. We are weeks away from a presentation to the Supreme Court that will be months away from making a decision that we really hope has the potential to turn some of this around right quick. To his right and to your left is Dan Takagi, Associate Dean for Faculty and the Charles Ebersold and Florence Whitcomb Ebersold Professor of Constitutional Law at Ohio State, a very old friend of mine, a long-time friend of mine, I should say instead, who has written books and articles that have been published everywhere. The list is far too long to go through. He graduated from Harvard and Yale and clerked for the same judge that I clerked for, Stephen Reinhardt, out in California, and then litigated cases at the ACLU and has been involved in his own slew of Supreme Court cases and other redistricting cases at courts around the country. I'm going to start off, so the title of this panel is How the First Amendment Can Help Us Think About the Redistricting Problem. And I'm going to start off by just very briefly describing the other ways to think about the problem and then ask the panel how they think the First Amendment may be different. So you've heard, whether you've sat in on some of the mathematicians' conversation or some of the quantitative folks' conversation, or you sat on some of the litigation conversation yesterday, you've heard that often redistricting is framed as a vote dilution problem, as a problem where the power, the outcome, is unfairly allocated. And there are lots of different ways to assess and lots of different ways to define, but the problem is defined in some way as the people don't have the sort of power they should have. That is, you can only assess vote dilution if you know what something's been diluted from. If I'm sitting with a Coke, I know when a Coke has been diluted because I know what Coke is supposed to taste like. Without knowing what Coke is supposed to taste like, it's very difficult to tell whether it's been diluted or not. And many of the theories of harm of gerrymandering have gone up to the court on this theory of, in some ways, vote dilution, sometimes under the 14th Amendment's Equal Protection Clause, sometimes under a due process theory, under different legal theories, but they essentially boil down to, has one party taken the power from another party in a measurable way that leaves them with less power than they should have had? That's not the only way to frame the question of the harm that partisan gerrymandering does. And the First Amendment, I think, comes at it a little differently. So I'm going to ask our panelists here, Emmett and then Dan, to describe how the First Amendment might show a different approach to the problem, a different approach to figuring out what's wrong with partisan gerrymandering. Emmett?
A simple way to view partisan gerrymandering is, under the First Amendment, is simply as viewpoint discrimination. The Supreme Court forever has taken the position that governments cannot engage in censorship, which is what viewpoint discrimination is, favoring some points of view and disfavoring others. And that the established Supreme Court law is that government can't even regulate speech or First Amendment conduct, which would include the right to vote. That's the way you express yourself at the ballot box. Or the right to join a political party, which is the way you exercise your right of political association. Or voting, again, is the way you petition government for redress of grievances. For most citizens, they don't write petitions, they don't go out in the street, they vote, or they don't vote. All of those are First Amendment protected activities. So it's basically fundamental law that government is not supposed to be engaged in censorship, in favoring different points of view, and so forth. What is partisan gerrymandering? But the party in power favors its own voters by enhancing the effectiveness of their votes. What do I mean by that? A party will basically sprinkle, for the lack of a better term, their votes evenly among as many districts as possible to create safe but not too safe majorities. And at the same time, remove from those districts as many opposition party voters, ethnically cleanse, if you want a pejorative term, those districts of people with whom they disagree, and put them in an ethnic ghetto called a packed district, where they will have supermajority votes, but their overall influence in the legislature or in a congressional delegation will be minimized to the maximum degree possible. Well, that's classic viewpoint discrimination. And if you apply First Amendment principles, the Supreme Court law is that that's simply presumptively unconstitutional unless a state can prove that there is a legitimate and compelling state interest that makes that necessary in order to achieve that perfectly legitimate and compelling goal. The beauty in the partisan gerrymandering cases, or the beast in them, if you want to look at it on the other side, is there is no one in any of this litigation ever who's ever said there's any legitimate interest to be served by partisan gerrymandering. There is no defense of it on the basis that it's good for America, that it's good for the democratic process, that it's good for voters, that it's an intelligent way to make decisions. And thus, the First Amendment is, it seems to us, a very attractive, very simple avenue for challenging partisan gerrymandering that is not asking the court to do anything it has not done over the last 40 years. The Supreme Court didn't really discover the First Amendment in a majority sense until the 1930s. Prior to that time, the courts had never invalidated anything on First Amendment grounds. And it was only in 1943 that they applied the First Amendment to the states. But with that historical aberration, if it is any, is that this is simply a simple theory in which the court is being asked to apply your existing precedents to stop it. It's that simple. And unlike, there are many cases, and Supreme Court's got a hard job. A lot of cases, if you decide to uphold a patent, for example, there are costs and there are benefits with that. You're giving somebody a monopoly and eliminating competition for some period of time over something that may or may not be a useful invention. And you're making decisions in which there are costs and there are benefits. The Miranda rule that excludes, for example, evidence of a person who is questioned while in custody without being advised of right to counsel, you exclude the evidence even though it may be totally admissible otherwise, totally incriminating otherwise, and the price is that you may be in fact allowing a guilty person to go free in favor of a broader societal goal of ensuring civilized, due process, intelligent waivers of constitutional privileges. In partisan gerrymandering, there is no baby to be thrown out with the bathwater. It is only the bathwater we're asking the court to throw out, which is tell legislators that you cannot favor your own party over the other party when you're drawing district lines. That is not very much to ask. It is not a hard rule to enforce because they enforce it and have regularly in many, many contexts over a period of years. So that is sort of the new approach in this case. It is not original with me. I wish I were that smart. It really comes out of a concurring opinion written by Justice Kennedy more than 10 years ago in a case called Veith against Jubiliera, in which all the prior cases, including the Wisconsin case that was just reversed by the Supreme Court, were brought under the Equal Protection Clause because that seems obvious. You're discriminating between Democrats and Republicans, and discrimination is something we understand. And they were statewide challenges. Well, Kennedy, in that opinion, says you can't do it this way. But he basically says to the lawyers, you've been barking up the wrong constitutional tree. You've been barking up the equal protection tree. You'd be better advised in future cases to bring these under the First Amendment. Because what is partisan gerrymandering except a form of viewpoint discrimination? And he cites well-established principles against political patronage, that when the Democrats take control of government in Chicago, they can't fire all the Republicans who are janitors, who are police officers, who are working in the parks departments, as street sweepers, and so on. So we're very encouraged about that theory, and we think that solves all of the issues that have been raised about manageable standards. How do we figure out whether or not something is unconstitutional? Well, the First Amendment does not distinguish between a little bit of prejudice or partisan or viewpoint discrimination. I favor Baptists some, but not too much. And I disfavor Catholics some, but not too much. It says you just don't do that. And you go back to historic cases that we all recognize now, which is Justice Jackson famously said in the West Virginia flag salute case, children who were Jehovah's Witnesses, that no government has the power to prescribe what's orthodox in politics or religion. What are you doing with partisan gerrymandering, except, and to quote David Lewis, the chairman of the committee that drew the North Carolina plan, it's better to elect Republicans than to elect Democrats. And that's why we draw the districts this way.
Dan, you've written a bunch about freedom of association in this context. How does the First Amendment fit in with, and how is it different from some of the other causes of action alleged?
Sure. Well, thanks, Justin. I want to answer your question, but first I would like to join you in thanking Common Cause as well as Duke for hosting us all. As a former state chair in California of Common Cause and a former member of the National Governing Board, now hard to believe 20 years ago, it's especially wonderful for me to be coming home and speaking at this event, and a special honor to be participating with my old friend Justin and
Long-time friend.
yeah, longtime friend. Yeah, right. Look at your hair, Justin.
Where?
As well as Emmett, who is, for those of you who don't already know, a legendary civil rights lawyer for whom I have long have the highest regard. So to answer the question, for a long time, I've felt, I must say, like something of a voice in the wilderness in arguing that voting should be, and indeed long has been understood, including by the Supreme Court, as a form of expressive association that is protected by the First Amendment. Now, I wasn't completely alone. There were others, including Guy Charles here at Duke, Lori Ringhand at Georgia, David Schultz at Hamline, who made arguments along these lines, but they weren't really getting a lot of traction even after Justice Kennedy's concurring opinion in Veith, which Emmett mentioned. But in fact, there's a long line of precedent involving the right of expressive association, which is really an outgrowth of the First Amendment's protection for freedom of speech. Starting back in the 1950s and 1960s with cases first involving the NAACP as well as the Communist Party, the court establishes there's this right that we all have to join with one another for expressive purposes, and especially for purposes of political association. Now, I want to make something clear, and this is where there's at least a shade of difference between what Emmett's just presented and what I'm suggesting. The Supreme Court has never said that voting is a form of speech protected by the First Amendment. It has, however, said, in some contexts at least, that voting is a form of association protected by the First Amendment, especially in cases involving parties, third parties, independent candidates' access to the ballot, as well as restrictions on the form of voting, like open primaries or blanket primaries. Right? The court has actually held this in a number of cases, and most notable among them is a case involving John Anderson's access to the ballot way back in 1980 in my state of Ohio. So, what does the First Amendment, and especially the First Amendment right of association, add to these other theories? Well, the first thing I think it adds, and I got 4, is you've actually got some pretty solid precedent to rely on, including precedent involving burdens on minority political parties. The second thing is that I think the First Amendment right of association better captures the nature of the injury that's inflicted by partisan gerrymandering, which at its core is a group-based injury. It's an injury that the group of people, the affiliates of the non-dominant party, experience by virtue of being denied an equal right to associate with like-minded voters, with their candidates of choice, and with the political party of their choice. Third point, and this is where Justin and I have a little bit of a disagreement that we can maybe get into later. A focus on the First Amendment right of association gets you a bit away from a legal standard that I think is a quagmire, and that is an intent-based legal standard. For example, in the context of racial gerrymandering, the court for now over 25 years has relied on this predominant factor, predominant intent standard, which in my view has turned out to be a quagmire. My co-author Dan Lowenstein at UCLA wrote about this way back when in the 1990s, saying you don't have to be a liberal to hate the racial gerrymandering cases, talking about how in the context of district drawing, a focus on predominant intent is not only difficult to apply, but at its root incoherent, given that you've got so many players in the process, and race is almost always a factor in drawing districts, and sometimes a precondition in drawing districts. I think partisanship is even worse. Look, you just can't have a test, in my view, or to put it more to the point, the Supreme Court is not going to go along with the test that there can be no partisan intent in redistricting, because that's going to wind up striking down virtually every districting plan in the country. That is a bridge too far, and much too far for the current Supreme Court. A better standard is the more nuanced standard that Anderson and that line of cases give us, which is basically a balancing standard where we balance the character and magnitude of the burden on voters against the specific interests put forward by the state. And that leads me to my fourth point. Look, we're not, the cases that are going up out of Georgia, I'm sorry, not Georgia, out of Maryland and North Carolina, they're going to be hard to win before the current court. With the new airline restrictions, I couldn't bring my shovel on the plane with me, so I'm not going to try to, in keeping with the profanity-laced theme of this afternoon, I'm not going to try to bullshit you here. These cases are going to be tough to win, but I want to make sure the best arguments are put forward. And in my view, the First Amendment association argument is the strongest argument. Don't take it from me. Take it from Justice Kagan, who, in her concurring opinion in the Wisconsin case last year, suggests a First Amendment association-based theory. And we can talk a little bit more about the kind of evidence and the kind of arguments that are worth emphasizing for that, but I think I've said enough to kick my part off, at least.
Well, you've said enough to annoy me, which is good.
That's my goal, Justin. Yeah.
I know. So given the outrageous slanderous remarks of my longtime friend, Dan, I just want to respond. I actually think we agree on most of this litigation, so this is fun. And it is true that the North Carolina case and the Maryland cases have the virtue of putting just about every theory up before the court that you can imagine. In fact, the North Carolina opinion itself from the trial court, we were talking about this earlier, it reads like a law school exam in that it tries out just about every issue there is and says, well, here's one way you could look at it, here's another way you could look at it. I don't know, you decide, Supreme Court. Here's the next way you could frame the case. I kind of think this, I kind of think that. I don't know, you decide, Supreme Court. It basically doesn't choose a theory. It says no matter what theory you choose, all of it's wrong. And the Maryland case adds a couple other theories, teeing everything up. And so I think actually the type of discussion that Dan prefers is compatible with what Emmett was saying. Dan's focus is on the impact of a particular gerrymandering plan. Emmett was focusing more on the intent. You can't aim to hurt somebody, and no matter how much or how little you do it, doesn't really matter, as he was saying. Under the First Amendment, if you change somebody's conditions of employment, if a government changes your conditions of employment, because you're a Republican or because you're a Democrat, for the vast majority of positions, that's illegal, right? Can't fire you, but also can't dock you pay. And they can't dock you pay whether it's $5,000 or $500 or 5 cents. Docking you pay no matter how much because you're a Republican or because you're a Democrat still unlawful. A legislature can't pass a tax plan that says necessarily if you're a registered Republican or you're a registered Democrat, you pay more in taxes. And it doesn't matter whether the number is $2 million more or $2,000 more or 2 cents more. That's clearly unlawful. That's the sort of thing that Emmett was talking about. That's much more based on intent. Here in North Carolina, you have the virtue of a record that kind of presents both easily. Right? There's really no factual question of intent. They wrote it down. And everybody agrees, a pretty profound impact in that what they wrote down was, we're going to try and get to a plan that's 10-3 in a state that's otherwise 50-50. And they achieved it durably, including in a wave year. You heard that from some of the other presentations this morning. So question back to you both. The Supreme Court has North Carolina in front of it, but is clearly looking beyond North Carolina in its decision, right? Whatever it does, it has already told us that it's worried about the cases to come, about all of the cases to come, the hypothetical cases to come and the real cases that are already teed up. How does a First Amendment theory help them for cases with records that aren't quite as extreme as the records in North Carolina? That is, how do you tell them that the First Amendment allows them to make a decision in the North Carolina case that helps them down the road?
Well, let me take it first. In my view, the court has been doing this in a wide variety of cases for 40 years. I mean, there's nothing controversial in the court about a statute, regulation that is content-based. That is something that falls within First Amendment protection, in which the consequences turn on its content, whether favoring or disfavoring or disadvantaging in some way, is presumptively a violation of the First Amendment. One that is intentionally viewpoint discriminatory, that is, you take the content and you say somebody who believes in being a Christian Baptist has better views than somebody who does not, or somebody who believes in free market economics, deregulation, and Republican principles is more worthy of voting, holding office, that sort of thing, than people who don't share those views. That's clearly content-based and is per se unconstitutional, is a constitutional injury. If to the extent the court is worried about future cases, that's a clearly established rule. They apply it in many contexts. When the state of Florida 3 years ago adopted a statute that said pediatricians can't discuss guns with parents about gun safety in homes so little children don't get killed, that was invalidated as content-based and viewpoint discriminatory, even if it was neutrally presented. It was a topic that was put off limits, and nobody thought that was unusual or difficult or anything of the sort. In gerrymandering, there are really 4 kinds of injuries. When you gerrymander the districts, as they do, you're sorting voters based on political beliefs, just as you're doing racial belief. You're deliberately putting a group of voters, disadvantaged voters, in what are called crack districts, in which they will be outvoted. Their vote is being diluted as compared to a neutral plan. That's one injury. 2, you're penalizing them because of their association with a particular political party. It may be by party registration, but you associate yourself with a political party by voting for its candidates. And that's what a partisan gerrymander does. And it injures them in other ways. It is hard, as you all know, to raise money for a candidate in a district in which that guy has no possibility of being elected. It ain't easy. It's hard to get volunteers in such a district. It is hard to turn out people to vote. They say, why should I vote if I'm a Republican, in the 1st Congressional District in North Carolina, there's 80% Democratic, in which I know that the outcome of the election is predetermined. There's a 3rd injury, which the court talked about in the racial gerrymandering cases, in which they say, the message you're sending to voters and to public officials is you've got to be in the select group to matter. The public official only has to respond to primary election voters because he knows the general election voter doesn't matter. The outcome is determined. What does that mean? He's afraid of being primaried. He cannot compromise. If you're a general election voter who are not eligible to vote in the Republican or the Democratic primary, you're not represented. You don't even get participate in the choice. And a fourth injury is, guess what? You have nullified the votes in the general election. The general election is reduced to a formality, just like the white primary cases. In the white primary cases, black folks couldn't vote in the Democratic white primary. So Texas created a private club primary called the Jaybird primary, which was before the Democratic primary, which was before the general election. They could vote in the general election. But the general election, the court said, was a formality. It was a celebration after the game was over. It was not one in which you had a meaningful vote. All of those are the consequences. So I agree completely with Dan, it's associational. I agree with others that it's dilutionary. I also agree that intent matters. Government ought not to be taking sides in political matters any more than they should in religious matters. And the core of the First Amendment is one of belief. You're free to believe in democratic socialism, in real socialism, in communism, in Republican free libertarianism. All of these things are part of our political mix.
So the question Justin asks is really the billion-dollar question. If the court is going to go down this road of striking down any redistricting plan as an unconstitutional partisan gerrymander, you're going to have to provide it with some assurance that there's a limit, that not every districting plan out there is going to be unconstitutional. And how can you do that? So one answer is that you have an appropriately nuanced legal standard like the Anderson-Burdick balancing test. But I actually think that that only gets you so far. I think the real answer to the question of how the court can limit its ruling while striking down the most egregious gerrymanders is to be very concrete and particularized and granular about how it talks about the evidence. And here I want to actually get back to something that was a theme of one of the morning panels in the other room, as well as our lunchtime discussion. It is essential, if we're going to win one of these cases, that we tell a convincing story, that we humanize this, as I think Allison said this morning in the other room, and Kathy sounded notes along the same times by talking along the same theme by talking about how real people are injured by partisan gerrymandering. For example, the story of the NC&T students. I think that's really good. While there are a lot of things I like about the opinion in the Common Cause versus Rucho case, the district court opinion striking down North Carolina's gerrymandering, as I was reading through that opinion while sitting on the floor at Dulles Airport last night waiting for my connection, it's a really long one, I felt like those stories really got lost, right? But to me, that's ultimately going to be the key to winning this case, is telling a story that puts the harms of partisan gerrymandering in human terms. Don't get me wrong, right? I love a good bar graph or S-curve or scatter plot as much as the next university professor. You got to have that evidence in the record, but that's not ultimately what's going to win these cases. And there's something else I want to emphasize, which I think is also pretty thin, at least in the opinions from both the North Carolina and Maryland case. It goes back to what Justice Kagan wrote in her concurrence in Gill, the Wisconsin case. We got to talk not only about the harms within the electoral process, but the harm to activists and political parties, grassroots organizers outside of the voting booth itself. She said that in addition to the electoral harms, which of course are at the heart of really the sum and substance of a vote dilution case, an associational rights argument should consider difficulties fundraising, registering voters, attracting volunteers, generating support from independents, recruiting candidates to run for office. And so I think in addition to the stories about how particular communities are cracked or packed and therefore their collective voice weakened, we need to tell stories about how activists and political parties and community groups are negatively affected outside the voting booth. And I really didn't see a lot of that. There was a little bit of it, but not a lot of it, and it was in very generic, general, if I might say, non-human terms that appeared in the Common Cause versus Rucho opinion. So I'm hoping that some of those kind of stories can be told before the Supreme Court, and I guess I'm hoping to help by submitting a brief that will try to bring some of that stuff in.
I was going to say, I'm sure the amicus lines are open. So please be thinking about the questions that you want to ask. I've got one more, but that's really an effort to stall, to give you all time to think of what questions you want to ask. The last question that I'll close with is, one of the things that those who are favoring vote dilution as a cause of action say benefits their cause is that if you know what the right power distribution should be, or at least the range of right power distribution should be, you know what the remedy is. You know what you're aiming for afterward, right? The map appears, it was diluted, so we just bring it back to where it should have been. What's the remedy for a First Amendment claim? The legislature has done something that burdens the right of association, or the legislature has done something that is beyond their power by discriminating against a particular political party. What happens then?
It seems to me the remedy is a prohibition that says, and this is sort of the nuance of some of this, nobody can perform a lobotomy on legislators. It may have been already done, but every legislator knows the potential political consequences of the action. Every legislator knows the racial makeup of the state and the areas with which they're involved. Every legislator knows that some counties are going to vote Democratic or likely to, and some are going to vote Republican. So the whole idea of Kennedy's opinion was you're not outlawing knowledge. That's a little bit hard to do, short of electric shock therapy or lobotomies. But what he says is, and he rejects an argument by Scalia that, gee, you're outlawing any partisanship. And he says, no, it is only when you use that information to, he uses the sanitized term burden, I would use the less sanitized term screw, people with whom you disagree. Favor your own people and screw the others. And it is that negative use that would be prohibited by the First Amendment. And that's what you do in all these viewpoint discrimination cases. You tell a little town in Nebraska that you cannot discriminate on your sign ordinance between people who are putting up signs about where to go to church and people who are putting up political signs. It's not that you're for one or the other or for one religion or the other. That's content-based, and you can't do it. So that's not hard. And the beauty of that is it's a standard that the dumbest legislator can understand. don't do it. Just like, I mean, they understand that you really would not want to get out in the legislature and adopt standards that said we're going to adopt a district that would give a 10-3 Baptist advantage over the Catholics in North Carolina. If you understand that, why don't you understand that you can't do it based on politics? And remember that you're not merely injuring Democrats or the Democratic Party, which is a party to the North Carolina case. You are elevating the effectiveness of the votes of your own people. It's a seesaw effect. It is not merely harming somebody. It is enhancing your own political power, entrenching yourself in office. And those are objectives that I think everybody on the court agrees are unworthy of a democratic process and therefore should be prohibited. And nobody should be terribly concerned about telling legislatures you can't do it.
So the question of remedy is also really difficult, and I think it's as Justin's question suggests, a lot of what's been holding the court back and making the court reluctant to enter this political thicket of partisan gerrymandering. If we do find that a particular redistricting plan is unconstitutional, well, what happens next? So on one level, I think the answer is easy. On the procedural level, well, we have a lot of experience with this in other contexts. One person, one vote, racial gerrymandering, Section 2 of the Voting Rights Act. What you do is you send the case back and the legislature or whoever the line drawer is gets another chance to do it. But that's an incomplete answer because it doesn't really tell the line drawer, usually the legislature, exactly how, right? Now, the opinion that's explained why the original plan was unconstitutional will give some guidance. I've said before that I think a standard that says you can't consider partisanship at all is a non-starter, at least as an initial legal standard, because if we apply that standard, virtually every districting plan in the country is going to be unconstitutional, and the Supreme Court, I will promise you, will not go down that road. Certainly not when there are 5 conservative justices on that court, and even with a majority of liberal justices, I don't think the court will go down that road. It's a different question, however, whether once you found an unconstitutional partisan gerrymander based not only on the effects and intent within the electoral process, but also these effects outside, the kinds of things that Justice Kagan mentions in her concurrence, it's a different question whether at that point, after a constitutional violation is found, a district court would have the authority to say, and now, given that you've sinned, you can't consider partisanship this time at all in drawing district lines, right? I think the court would be unwilling to impose that as a legal standard on everyone, but maybe at the remedial stage, as I think Emmett is suggesting, that might be an appropriate constraint on the on a state that's been found to have violated the Constitution.
So now it's your turn. I'm going to learn from Kathy as I always learn from Kathy, and that is to encourage if you have been responding for the entire conference, please hold it back in for just a little bit. And if you have not been responding for the entire conference, please let your inner questioner fly. Suzanne's working her way around. Yes, please.
Okay, this is this on?
Yes.
This is a quick question. If you were going to put some money on which justice you think would flip to make it, which conservative justice would go for strike down a gerrymander first, who would it be? Go.
Okay, I'm going to take Emmett off the hook since he's going to be he's part of the legal team that's arguing, because I have a little more freedom on this. I have zero hope for Justice Thomas, for Justice Gorsuch, and pretty close to zero on Justice Alito. I think there are 2. That leaves two from which we can get the fifth vote. That's Chief Justice Roberts. His line of questioning at the Wisconsin argument was not very encouraging. It's pretty clear that he's going to be reluctant to find a constitutional violation based exclusively on statistical evidence, right? He referred to what was a gobbledygook or something like that, which is unfortunate, but that's just the reality. Justice Kavanaugh, he's got a pretty conservative track record as a D.C. Circuit judge. I wouldn't put the chances of getting his vote as high, but I don't think they're zero either, because we just don't know very much about him and where he stands on voting rights issues generally, since he had really one significant case that I'm aware of in the voting realm, as opposed to campaign finance, where we know a lot more about him. So, there's this theory floating around, which is really nothing more than speculation, so take it with that grain of salt. Like a lot of people, I thought that his performance at the end of his confirmation hearing was appalling, right? The theory is, well, he may want to show the world that he's not the partisan hack that he appeared to be during his confirmation hearing. I don't know. I mean, your guess is as good as mine on that one.
Real quick, and I'm not going to make Emmett answer this question either. As one of the folks arguing before the court, you don't like to tell the court which people you're hoping for.
All.
Right.
Dare to dream.
9-0. I agree entirely with Dan. The one thing I'll add is that the Roberts Court, he's been the Chief Justice for a while. It's now really his court, because before it was the Kennedy Court. We just didn't call it that. But the Roberts Court has been quite protective in the First Amendment zone. In fact, some might say overprotective. If there's been a complaint, it's that the complaint is that they've been calling a lot of things that aren't speechy and saying you can't regulate that. But that means especially vigorous prohibition on the government using its own governmental tools to punish people based on what they think and believe. And that's essentially what this claim is. And so for those who are just focused on conservative judge or liberal judge, these justices have demonstrated that they are not okay with governments picking winners and losers based on speech pretty aggressively so far. And the Chief Justice has been leading that charge in many ways.
Hi, my name is Alec Colson. I'm working on redistricting reform here in North Carolina. Actually, you kind of teed up my question in some ways. And I want to be transparent in that I am hoping for suggestions for a specific problem here in North Carolina. It has to do with Section 2 of the Voting Rights Act, which we know Justice Roberts, when he was at DOJ, I think opposed the amendment that went to the results test. Also, you spoke earlier about compelling state interest. And you've spoken earlier also about how in North Carolina you can't really talk about partisan gerrymandering without also talking about race. And one enduring...
The legislature is trying real hard.
Yeah, they try really hard. Trust me, I spent a lot of time at the General Assembly. David Lewis is he's like the Joker to my Batman. I mean, it's crazy. But so speaking of, there is an enduring, possibly... an enduring misunderstanding in North Carolina that Section 2 of the Voting Rights Act requires majority-minority districts. That was the excuse they used in drawing the 2011 maps, even though the Gingles or Jingles case was actually a North Carolina case, so they should have known better. So whatever other standards we talked about, First Amendment or whatever, they're going to be tempted to go to saying that's their compelling state interest, which is what they've done before and gotten away with it. And I see even in just a lot of places that sort of an enduring misunderstanding. And then you talked about the courts and what's going to happen. I don't know if we can even rely on the Supreme Court anymore. So I have been wondering or thinking about a possible state solution where we build in some kind of results test, like Section 2 of the Voting Rights Act, into the state language. And so that, I know it's sort of a very general question, but since you're all experts in that area, I thought you might have some, first, do we think Section 2 is at risk of being struck down in some way and at this Supreme Court level? Any suggestions in speaking about it in a way that even legislators can understand? And also, if have you ever seen or contemplated someone trying to put that into a state, that concept into a state statute? And are there kind of any gotchas that there might be some good reason not to do that I wouldn't know? And I apologize for the long-winded question, but thank you for listening.
So I'll take a 30-second stab at that, and then I want to turn it over to the panel, and then I want to get like one or two other questions in before we run out of time. The 30-second stab. So this is a question about essentially the Voting Rights Act and its interaction with gerrymandering. The question started off by saying there's a conception that you have to pack minorities into districts. That's part of what creates the overpacked Democratic districts, because in North Carolina, when you overpack African Americans, you're also overpacking Democrats. And the North Carolina legislature got reprimanded for doing exactly that in the case that brought us the current map. So in a case called Cooper versus Harris, the Supreme Court told the North Carolina legislature, which, yes, should have known better, that's not what we meant. It's not that the Voting Rights Act doesn't apply in North Carolina, but in Districts 1 and 12, you didn't show us that the communities of color were having any problem electing their candidates of choice already. So there's no reason to shove a bunch of other people into those districts. North Carolina legislature has misunderstood exactly what Cooper said, or strategically misunderstood exactly what Cooper said. First, they said, well, that means we can't consider race at all. No. Then they said, well, we don't have to consider race at all because the Voting Rights Act just doesn't apply in North Carolina. No. So there are lots of willful misunderstandings in this zone. And I don't know that different statutory language is going to fix the willful misunderstandings. But if you're looking for examples of statutory language, there are a bunch of states that have in their own state statutes or their own state constitutions. Some have explicitly referenced the Federal Voting Rights Act. So some state constitutions say the first thing we do is satisfy the Federal Voting Rights Act. And then there are other states that have actually replicated the language without referring to the Federal Voting Rights Act, that have their own state constitutional or state statutory protections. California has one. Washington State just added one. And in some ways, you were asking about, concerns that might have been, or traps that might have been laid there. Washington State responded to some of the concerns that California was encountering. So there are models out there. And frankly, states ought to consider racial equity measures built into their own state law, independent of the strength or continuing viability of the Federal Voting Rights Act. It turns out that we have a strong commitment in this country to majority rule, and an equally strong commitment in this country, when you ask people about their bedrock convictions, to minority representation. If you ask in the abstract, that gets wildly bipartisan, wildly high levels of support across the aisle, across preference, across racial lines, right? We believe in both of these things. And it would be nice if it were enshrined in state law just as it is in federal law.
I'm just going to say a couple quick things about Section 2 of the Voting Rights Act. First of all, I love Section 2. I love its focus on results rather than requiring plaintiffs to show intent to challenge districting plans and other schemes that dilute the vote. But you know who doesn't love Section 2 of the Voting Rights Act and is much more important than me? Chief Justice Roberts. So yeah, to answer a part of your question, I am really worried about the future of Section 2. I don't think it's probable that the court would be so reckless as to strike down Section 2 in its entirety as unconstitutional, but I think there is a big chance that it will whittle it away by raising the threshold for what plaintiffs, voting rights plaintiffs, have to show in order to prove that a minority group's voting rights have been unlawfully diluted in violation of the Voting Rights Act. And let me bring this conversation back to the subject of partisan gerrymandering by noting, because of Chief Justice Roberts' skepticism of the Section 2 results test, I would be really leery about making explicit comparisons to the Section 2 vote dilution standard in arguments challenging the partisan gerrymanders in Maryland or North Carolina. That is not the kind of argument that's likely to win Chief Justice Roberts' vote, in my view. Yet I saw in the Maryland motion to affirm that I was reading last night, they actually did make an argument analogizing the partisan gerrymandering standard to Section 2. Boy, I think that's a big strategic mistake.
Emmett?
I'll pass.
Pass for Mr. Bonrod. Mike is, yes, sir.
Hi, my name is Zach. I go to school at Duke.
Excellent.
This might be a stupid question, but it popped in my head. Is it possible that the court will say, talking all about this First Amendment as an argument against gerrymandering, that, and I feel like I've read this before, that it's a First Amendment right to gerrymander for the state legislators? I'm not saying I believe that. I'm just wondering, could that happen? Could that be argued?
It's a reasonable question. The answer is no, because it's we, the people, who have First Amendment rights, not the government itself. Now, legislators as individuals certainly have First Amendment rights, but when acting as a government to enact a law, that's not something they have unrestrained discretion to do. Rather, they are bound by the Constitution rather than being rights holders under the Constitution in that context.
Got time for one more question, I think. Your choice.
Thank you. Mark Friedman from Raleigh. I'm neither a professor or a lawyer, just an increasingly incensed citizen in this
Thank
state. Tired of the nonsense, and I think it peaked a few years ago, when David Price, who spoke to us yesterday, was gerrymandered out of my district. So I've now sat through a day and a half of these discussions, and I would say that the arguments fit a three-pronged test I would apply to it. They make common sense, perfect common sense. Second, there's empirical data that confirms the violations of the law. And maybe even more so, the third point would be that the arguments sound completely fair. So my question, and maybe this goes back to my own naivete about Supreme Court cases, what are the arguments that the other side, there's always two sides to a story, what are the arguments the other side would make that causes this to be such a tough thing to win? Because it just seems like this should just be overturned.
It's a magnificent closing question. Thank you.
Great question. I actually think some of Justin's questions suggest the answer. And to me, they're really two big ones. The first is the line drawing problem. It's a really hard line drawing problem. In contrast to one person, one vote, where the court was able to basically come up with a pretty clear quantitative standard for what's constitutional and what's not, we're not going to get a bright line rule here. And the second is the remedial problem. That's a big part of what leads me to be, well, not overly optimistic about the chances of winning right now. Now, that's bad from my perspective as a lawyer, but it's good from all of your perspectives as citizen activists in a way, because it means, and we've seen this especially in the last election cycle, the biggest opportunities for redistricting reform are in your states, right? Especially through the initiative process, but there are also places like my home state of Ohio in which we were able, with the hard work of Catherine Terser in particular, to get the state legislature to see the need for redistricting reform. So we focused on the law and court cases here, but I don't want this to be understood as in any way implying that the efforts that all of you are engaged in here and in other states are anything less than the most important source of reform energy right now.
Emmett, take us out. You got a minute.
Well, my own view is that assuming you apply consistently existing principles of First Amendment law, that is, that prohibits viewpoint discrimination, intentional viewpoint discrimination, there are no lines to be drawn. The court has not drawn lines in which it said a little bit of viewpoint discrimination is okay as long as you don't go too far. A little bit of viewpoint discrimination is okay as long as it doesn't have an enduring effect for a century or a half century or multiple elections. In other election areas, they've never said that it's okay to rig one election as long as it doesn't go to the next election cycle. It is this effort to create the idea that only extreme gerrymanders are okay, and as long as you don't screw people too much, the Constitution doesn't care, that gets you into judgments and line drawing. And they don't do it in the First Amendment area. There is no room for that line drawing in the First Amendment. So unless you're going to be unprincipled, and of course we would know the court would never do that, I'm very optimistic that this is the simple way out. And remember, the way you generate a lot of complicated litigation is you give vague, complicated rules about how much is too much, because every legislator you know will be pushing the limit on how much is too much, and every litigator like me will be pushing the limit on that much is too much. And that just generates complicated, very expensive litigation, whereas a clear rule, like the one man, one vote rule, one person, one vote, don't do it, has not generated a lot of cases. So I am optimistic. I think we're going to win. I'm counting on a 9-zip opinion.
That's as good a place to close as any. Please thank the panel with me.